Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's live stream, we are dealing with a freshly issued United States Supreme Court opinion. We got some brand new law, a little Fourth Amendment law with some Second Amendment overtones for you today. This is the case of CANIGLIA versus STROM from Rhode Island. In this case, the police seized some guns from somebody without permission, and they tried to go with a community caretaking exception. Okay, so this guy apparently had threatened to harm himself with a firearm the prior day. The next day, the police come and they say, "Hey, would you go get mental health treatment?" And he said, "Okay." So he's now consensually gone off to a hospital for some mental health treatment dealing with this thing. But apparently at some point in this exchange, the police asked him, "Can we have your guns?" And he said, "No." Okay? So the police now go into his house, conduct a search because they're not in plain view, find the firearms, seize the firearms, keep the firearms. And so the police don't have a warrant, they don't have permission, they don't have exigency. They have none of the standard things that would allow the police to do this. So we're trying a new category of thing, a new reason that the police say we can do this, called community caretaking. So maybe we don't have a warrant, maybe we don't have permission, maybe we don't have an exigency, but let's try a new category of thing. How about community caretaking? We want to go in and take the firearms because of community caretaking. So this was a question. Is community caretaking a thing in the home? And the answer appears to be no. And Rhode Island says, guns are really scary though. And the Supreme Court says, stuff it. Excellent. So we're going to read this decision, and we're going to read some brand new law, fresh off the presses, man. It just happened right before our eyes. How amazing. So let us do all that. In the case of CANIGLIA versus STROM. Written by Justice Thomas, so this should be fun. On behalf of a unanimous, say it with me, unanimous Supreme Court 9-0. Fun. Decades ago, this court held that a warrantless search of an impounded vehicle for an unsecured firearm did not violate the Fourth Amendment. In reaching that conclusion, the court observed that police officers who patrol public highways are often charged to discharge non-criminal community caretaking functions, such as responding to disabled vehicles or investigating accidents. The question today is whether this prior law acknowledges of these caretaking duties, creates a standalone doctrine that justifies warrantless searches and seizures in the home. It does not. So many moons ago, we said, okay, there's a community caretaking thing in a car. Police sometimes respond to car accidents that are non-criminal. Police sometimes respond to disabled vehicles that are not criminal. Sometimes abandoned vehicles that are not criminal. And they may wind up towing these cars. And they may wish to conduct a search of the cars after they tow them. Now, one could presumably justify this on the basis of an inventory search, because we want to make sure that we give you back exactly what we took from you in the first place. So we're going to look in the car to figure out what's there to make sure that you get back everything, right? We don't want you to say, oh, there was something in the trunk that you didn't get back, so we'll inventory it. But whether or not that makes sense under its own terms, we can tow the car even though no crime has been taken, and then we can search the car pursuant to it, creates its own rationale. The way the Supreme Court wrote this many, many moons ago was to say, okay, there's this category of thing called community caretaking exception that applies to the car. And of course, then the next logical question, right, or at least a logical question that follows is, okay, if community caretaking is a thing that applies in cars, does it apply in other contexts? Is this a car-specific thing, or is this a general thing? So someone said, okay, there's this thing, community caretaking exception. We think it's a general thing. We think it's a standalone rule. The car thing was an example you found, but it was merely an example. It was an example of the broader rule. So we want you to say it's a standalone thing. And if it's a standalone thing, then presumably it would apply to the home, at least under some terms, because it's a standalone thing, right? So the Supreme Court says, okay, is it a standalone thing? No, it's not. Excellent. Well, that's good news. This is good news for Fourth Amendment lovers everywhere. All right, let's get into some of the facts here, okay? During an argument with his wife at their Rhode Island home, Edward CANIGLIA retrieved a handgun from his bedroom, put it on the dining room table, and asked his wife to shoot him now and get it over with, or words to that effect. She declined, and instead left the night to spend the night at a hotel. The next morning, when petitioner's wife discovered that she could not reach him by telephone, she called the police to request a welfare check. This all sounds fine so far. My husband has threatened to kill himself. I can't reach him by phone. Please, could you go check to make sure, it worked out okay. Okay. Respondent, the wife, the respondents accompanied the petitioner's wife to the home. So the police pick her up from the hotel or whatever. They all go to the home together, where they encounter the petitioner on the porch, the guy. He's obviously not dead. Petitioner spoke with the respondents and confirmed his wife's account of the argument, but denied that he was suicidal. At least at the moment, he's not. Respondent, however, thought the petitioner posed a risk to himself or others, which is probably a fair assumption if he doesn't deny the statements from the night before, right? We're not sure we're necessarily inclined to believe your statement about you not being suicidal right now. So they call for an ambulance, and the petitioner agrees to go to the hospital for a psychiatric evaluation, but only after respondents allegedly promised not to confiscate his firearms. So he's sitting on the front porch of his Rhode Island home when the police and his wife show up, and the police say, Did this encounter happen last night? And he says, yes, but I'm not suicidal. And the police say, we'd really like you to go get some psychiatric treatment. Now, whether or not they can compel him to do so or not, I don't know, nor do I have to answer that question right now because it didn't happen, right? So I don't have to answer the can they compel him question because that's a different set of questions. But they said, would you mind going? And he says, okay, but I'm only going to go if you promise not to take my firearms. Or even if they didn't say that, he could have just said, you don't have my permission to take my firearms, which would have been enough. So even if they didn't promise, for Fourth Amendment purposes, it would be enough, right? You don't have my permission to take my firearms. So I will go to the hospital. You don't have permission to go my firearms. And whether or not they promise or not, doesn't really matter. Also, even if they did promise, it's almost certainly not enforceable because, there's no consideration in this contract. And going to the mental health hospital is probably not legal consideration in this situation because it is not a bad benefit in any sense. So probably not a legal consideration. So there's probably not a contract. So you can't probably enforce this in contract law. And there's public policy reasons. So anyways, it doesn't matter. The petitioner, the guy, sues, claiming the respondent violated the Fourth Amendment when they entered his home and seized his firearms without a warrant, which they had to search for. They weren't in plain view. So not only did they have to enter the home without his permission, which they probably can do because it's also her home, right? But he objects to taking the firearms. So even if they can get as far as a search, they can't get to a seizure because he says no. And because he says no, under the relevant law, that wins. Right? The district court grants summary judgment to the respondents, the police, and the First Circuit affirms solely on the ground the decision to remove petitioner and his firearms fell within this community caretaking exception to the warrant. So the First Circuit says, yeah, community caretaking is a thing in the home. So you can seize his firearms. And also, incidentally, never give them back, because that was a whole thing. Citing this court's statement in Katie that police officers often have non-criminal reasons to interact with motorists on public highways, and fair enough, the First Circuit extrapolated a freestanding community caretaking exception that applies to both cars and home, which is a plausible extraction. extrapolation. Because, like, here is a thing. Okay, what is the domain of this thing? There is now a thing. What is the domain? Okay, we say the domain is basically unlimited, which is a reasonable, although ultimately wrong, extrapolation. Accordingly, the First Circuit saw no need to consider whether anyone had consented to the action, which is fair enough, because consent would be a different argument under the Fourth Amendment, right? Consent is a different thing, right? So if the police are legally protected by community caretaking, then we don't need consent. Perfectly logical, yeah. Whether the actions were justified by exigency, which again would be a different category of thing. If we have exigency, if we have community caretaking, we don't need exigency, or whether any state law permitted this kind of intervention, which might also be its own category. So we're trying to create an entirely new category, and if this category applies, then we don't need any of those other reasons, which is fair. If this reason is sufficient, then all those other reasons, we don't need them. So the First Circuit said, okay, we think that there's this reason, so all that other stuff is as to an irrelevancy, which is a logical conclusion if you accept the premise that it exists. All that mattered was respondents' effort to protect petitioner and those around him, distinct from the normal work of criminal investigation, fell within the realm of reason, which sounds like a suspiciously broad thing to me. Right? Oh, the realm of reason. The police have a realm of reason to enter my house and seize my stuff. That doesn't sound scary in any way. And generally tracked what the court viewed to be sound police procedure. The Supreme Court grants certiorari. The Supreme Court has some thoughts they'd like to share with the First Circuit about all that. So we're going to take another crack at it, First Circuit, and we're going to let you know what we think. That's interesting and all. Let me tell you what we think. Here's what we think. The Fourth Amendment protects the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. The very core of the guarantee is the right of the man to retreat into his home and be free there from unreasonable intrusion. As we like to say on this channel, the house is special. The home is special. The home is the place of ultimate refuge. It is the place where one's rights are at their absolute maximum. The home is one's castle. They are the place the most absolute maximum. So whatever the Fourth Amendment, probably for that matter any other amendment, but whatever the Fourth Amendment means, it must mean it's most at the home because the home is special. To be sure, the Fourth Amendment does not prohibit all unwelcome intrusion on private property, only unreasonable ones. We have thus recognized a few permissible invasions of home and curtilage. Perhaps most familiar, for example, are searches and seizures pursuant to a warrant, which, is right in the text of the Fourth Amendment anyway, but yeah. We've also held that law enforcement officers may enter private property without a warrant when certain exigencies exist, including the need to render emergency assistance to an injured occupant or protect the occupant from imminent injury, or chasing a fleeing felon, or trying to recover a kidnapped baby, or emergencies, preventing the destruction of drugs. I'm not sure how you destroy a gun in this time frame. Can't exactly flush it down the toilet, probably. And of course, officers may generally take actions that any private citizen can do, such as, for example, approaching a home and knocking on the front door, and then leaving. But yeah, they can do anything that a normal person could do. The First Circuit's community caretaking rule, however, goes beyond anything this court has recognized. Well, I think that much everyone concedes. That would be why it's a new category, right? If it didn't go beyond anything that we've recognized, then maybe it's just an extension of one of the previous categories, or a modification, or something. But no, this is I think everyone concedes that whatever this thing is, it is not merely an extension or modification of what's come before. We're creating an entirely new classification of thing. We already had warrant, we already had consent, we already had exigency, and now we want to create an entirely new fourth category, community caretaking. I think everyone concedes that whatever this is, it's definitely none of the previous three things were an extension thereof. It's an entirely new beast of thing. The decision below assumes respondent lacked warrant or consent, which they seem to lack both of those recordly. I mean, not so much assumed as that's factually true. And expressly disclaimed the possibility that they're reacting to any crime, which would be hard because there's no crime in progress at that particular moment, not for the least of reasons that at the moment he's not there. He's in the ambulance on his way to the hospital, remember? The court also declined to consider whether any recognized exigency circumstances were present because respondents had forfeited the point. So the lawyers for Rhode Island, maybe because specifically they wanted this community caretaking exception. So maybe it's not a mistake. Maybe it was a very deliberate choice on their part. Maybe Rhode Island said, we are going to forfeit exigency argument very deliberately because we want to clarify that we have this fourth category of thing. So maybe that wasn't a whoopsie so much as a strategic choice. How about exigency? Yeah, we waived that. We don't care. We want this community caretaking thing. Well, that's a valid choice. That's a valid choice to make. It's like, I don't want to argue that position. I want to argue this position. Okay. Nor did it find respondents' actions were akin to what a private citizen might have authority to do if petitioner's wife had approached a neighbor for assistance. Yeah, this is a private citizen can't do this either. A private citizen can't just go into someone's house and take their stuff, specifically when the person says no. There's a crime for that. Neither the holding nor logic of Katie justifies the approach. True, Katie also involved a warrantless search for a firearm. That's true, but it's in a car that might be disabled, that had to be towed, and blah, blah, blah. But, and most importantly, because the search was in an impounded vehicle, not a home, the home is special. It is more special than a car. Who knew? Because the search was in an impounded vehicle, not a home, a constitutional difference that the opinion repeatedly stressed. The home is special. The home is not a car. In fact, Katie expressed contrasting its treatment of a vehicle already under police control with the search of a car parked adjacent to a dwelling place of the owner. Katie's unmistakable distinction between vehicles and homes also takes into place proper context its reference to community caretaking. This quote comes from a portion of the opinion explaining the frequency from which vehicles can become disabled or involved in accidents on public highways often requires police to perform non-criminal functions. That seems very plausible. Cars break down. Cars get into accidents. Cars run out of gas. Sometimes cars are abandoned. These may or may not be criminal. The police may not have to do something about it anyway. So, yeah. But this recognition that officers perform many civic tasks in modern society was just that. A recognition that these tasks exist and not open-ended license to perform them anywhere. So police officers have some responsibilities that may not be criminal as to cars, for the sake of maintaining traffic flow and, blah, blah, blah. But not sure how any of those examples pertain to a home. Homes don't run out of gas. They don't break down on the highway. So, they don't. They're, no. What's reasonable for vehicles is very different than what's reasonable for homes. Cody acknowledged as much, and this court has repeatedly declined to expand the scope of the exceptions of the warrant requirement to permit warrantless entry in the home. We thus vacate the judgment below and remand for further proceedings. So, go stuff it. It's so ordered. In a fairly short opinion. It was only 4 pages long. Yeah, it was 4. Well, yeah. It was 4 pages long. Well, that's a short opinion. There's nothing more to say, man. Okay. Well, not every decision has to be 30 pages long. Sometimes we say everything we need to say in 4 pages, man. So we said everything we need to say in 4 pages unanimously. The community caretaking thing is not a thing that exists in the home. It doesn't exist. That seems to be the pretty clear takeaway of this. The community caretaking exception does not exist. as to the home. Not a lot of ambiguity on that one. Seems pretty clear to me. What about this? What about this? What about this? Well, the Supreme Court just shut you down pretty hard. They said in 4 pages, how about never? How about none of the times? We don't need to say a lot more verbiage. And, as to legal analysis, not all of that was legal analysis because some of it was, So it wasn't even 4 pages to be quite honest, because the first entire 2 pages was a factual background, right? So the first 2 pages of the opinion are, here are the facts. Here is something we decided before. So the first paragraph and pretty much half of page 1. So the first half of page 1 is, here is something we've decided in the past. Then the remainder of page 1, all of page 2 is, here is the facts of this case. And then page 3 and page 4 are legal analysis. So it wasn't even really a 4-page opinion. It was a 2-page opinion. 2 pages. Unanimous. End of analysis. There is nothing more to say. 2 and done, baby. 2 and done. You have to write as much as you need to write. And it's like, well, that's all I have to say about that. Community caretaking doesn't exist. Go away. What more do you want? All right. So there appears to be a concurring opinion. So Chief Justice Roberts and Breyer would like to offer some additional thoughts for some reason. 15 years ago, this court unanimously recognized the role of a peace officer includes preventing violence and restoring order, not simply rendering first aid. A warrant to enter a home is not required, we explain, when there is a need to assist persons who are seriously injured or threatened with this injury. Nothing in today's opinion is to the contrary, and I join it on that basis. So they just wish to make clear that a prior exception relating to exigency exists, which nothing in the primary opinion said it didn't, because remember, we were in an entirely 4th category. That was the whole point, right? So this previous thing, which dealt with exigency, where there's a need for medical assistance, we weren't really talking about that at all because we were trying to talk about this mysterious 4th category, which, by the way, we say doesn't exist. So just as a reminder, we didn't undo that other thing because of course we didn't. So, yeah. And then Justice Alito has some thoughts he'd like to share. I join the opinion but write separately to explain my understanding of the holding and highlight some important questions the court does not decide. Okay, so he wants to say, here's some things I want to highlight. Here's some things that might be problems in the future. Fine. The court holds, and I entirely agree, that there's no special 4th Amendment rule for community caretaking. As I understand the term, it describes many police tasks that go beyond criminal law enforcement. These tasks vary widely, and there's no clear limit how far they might extend, which is part of the problem when they're unlimited. The category potentially includes any non-law enforcement work a community chooses to assign. And because of the breadth of activities that may be described as community caretaking, we should not assume the 4th Amendment commands reasonableness applies the same way to everything that applies in the same category. Yeah, I suppose that's a fair point. So community caretaking, as it's currently conceived of, would be non-criminal, at least in its nature. Because everything else, well, almost everything else, except, yeah. So Alito's just making the point that maybe there's something that falls within the broad spectrum of community caretaking that we'd recognize separately, but not the entire broad category. So maybe we'd recognize some sort of species of it, but not the genus. Which, if you view giving aid to someone who needs immediate medical aid as community caretaking, which it probably does. I mean, no one's ever put it in those terms, but that would be logical. So, I mean, taking care of someone who needs emergency medical aid isn't a warrant, it isn't consent, it isn't exigency, because normally when you think exigency, you're thinking exigency specifically related to criminal. That's why I don't think it's exigency. So normally when you're thinking exigency, you're thinking specifically criminally related exigency. So maybe taking care of someone's emergency medical health is a type of community caretaking. But even if it is, and maybe there's other things like it, we're still not going to recognize the entire category of things because that would be dumb. Okay, fair. Maybe there's some specific thing that we'd recognize, but not the general thing. Okay. Maybe. I'm not, maybe. The court's decision in Cody does not recognize any freestanding rule. The opinion merely uses the phrase community caretaking in passing, which I think is a totally fair thing, and another way to do this. Is another way to decide this, and it's perfectly fair. When we said community caretaking, we were just merely trying to... It's basically dicta, and so don't read it for more than it is. It wasn't really a legal rule as such. We were just kind of describing something, and you read way too much into it. Truth for Liberty gives me 1776. Thank you very much. Kavanaugh is waving in as associate for loose standard of exigency. Not good. Well, we haven't gone to Kavanaugh so far if he has an opinion. And the degree to where, and the standards for exigency are kind of open. In fact, the Supreme Court's considering a decision on that right now relating to fleeing non-felons, fleeing misdemeanors or misdemeanants. So, fair point, but thank you very much for the super chat. That's very, very kind of you. It's super appreciated. While there's no overarching community caretaking doctrine, it does not follow that all searches and seizures conducted for non-law enforcement purposes must be analyzed under the same rules. These rules may or may not be appropriate. We do not decide it. So, fair enough. Fair enough. Maybe someday something specific. But, yeah. The case falls within one important category of cases that could be viewed as community caretaking, conducting a search or seizure for the purpose of preventing a person from committing suicide. Assuming the petitioner did not voluntarily consent for a psychological assessment, he was seized and thus subject to deprivation. But was it reasonable? Well, I don't know, because we're not talking about seizure of the person because he consented. So could you have seized the person? I don't know Rhode Island well enough. Probably. I mean, or more the point, I guess, is it possible for Rhode Island to write a law that would pass constitutional muster, that would allow the government to seize this person under this set of circumstances? Probably. Given what we know, probably. So, I mean, for a short period of time, right? It would have to be a very short period of time for a psychological exam. So it could be some, like maybe a 24-hour hold or 72-hour hold, something like that, maybe. But yeah, could you pass some version of some law that would pass constitutional muster under these circumstances? Probably. But, that's not our immediate question today. We've addressed standards required by due process for involuntary commitment to a mental health facility, but we've not addressed Fourth Amendment restrictions on seizures like one that must be here, a short-term seizure. So long-term seizures, we've definitely dealt with that. That would be involuntary commitment. Short-term seizures, we haven't really dealt with that issue. Every state has laws allowing emergency seizures of a person for psychiatric treatment, observation, or stabilization. But the laws vary in many respects, including the category of persons who may request the actions, the reasons, the necessity, and the nature of the proceeding. Mentioning these laws only in passing, petitioner asks us to render a decision that could call features of these laws into question. The court appropriately refrains from doing so. Yeah, we're definitely not going to do that today. The laws are too disparate. To analyze them in gross. But yeah, there's probably some version of this law that's constitutional. Not necessarily every version of this law. So what exactly are the boundaries of that? Well, I don't know, and neither does anyone else. Because there's no Supreme Court case on it, right? But, that's too esoteric for today. The case also implicates another body of law the petitioner has glossed over, so-called red flag laws that some states are now enacting. These laws enable police to seize guns pursuant to a court order to prevent their use for suicide or infliction of harm. They typically specify a standard that must be met and procedures that must be followed. Provisions of red flag laws may be challenged under the Fourth Amendment, and those cases are not today, and we don't decide that today. Yeah, same thing as before. Are the red flag laws constitutional? Well, maybe it's a slightly different question. Is it possible to write a red flag law that would pass constitutional muster? Probably, but, exactly what are the domains of that? Who knows? No one knows because we don't have enough law in it yet. So probably, yeah, but we're definitely not answering that right now. One additional category of cases should be noted, those involving warrantless, non-consensual searches of a home for the purpose of ascertaining whether a resident is in urgent need of help and cannot summon help. At oral argument, the Chief Justice posed such a question that highlights this problem. He imagines a situation in which neighbors of an elderly woman called the police and expressed concern because the woman had agreed to come over for dinner at 6, but by 8, she had not appeared or called, even though she's never late for anything. The woman had not been leaving her home, and she was not answering the phone, nor could her neighbors reach her or her relatives by phone. If police entered the home without a warrant, would that violate the Fourth Amendment? I don't know. We know if the person needs help, they can enter it. But what if we're not sure? But we have reason to think it. Probably. But again, that's going to be very fact specific, so we're not going to enter that today. Petitioner's answers that way it would. Indeed, he'd argue even if 24 hours went by, the police still cannot lawfully enter. The situation remained unchanged for several days, he suggested. The police may be able to enter after obtaining a warrant for a missing person. The Chief Justice's question concerns an important real-world problem. Today, more than ever, many people, including elderly, live alone. Many elderly men and women fall in their homes or become incapacitated for other reasons. And unfortunately, there are many cases when they can't call for assistance. Well, they need life alert. They need the life alert because of the fall and they can't get up thing. In those cases, the chances for good recovery fade with each passing hour. So in the Chief Justice's imaginary case, if an elderly woman was seriously hurt or sick, and the police heeded the suggestion about what the Fourth Amendment demands, there's a fair chance she would not be found alive. This imaginary woman may have regarded her home as her castle, but it's doubtful she wanted to be the place where she dies alone and in agony. Yeah, there's probably some version of these facts that would be sufficient, right? We don't necessarily need to define exactly where they are, but if we know the person needs help, we can enter because we have case law on that. So if we know that, we can do it. What if we don't know it, but we have lots of reason to suspect it? I mean, the Fourth Amendment does just talk about unreasonable searches, so is there some version of this that would be lawful? Maybe. Do you need some sort of warrant? Maybe. It would be an administrative warrant rather than a judicial warrant in this case, because it's non-criminal in nature, but there's probably some version of that that's constitutional, but exactly what the boundaries of that, again, we don't know. We can't answer that right now. It's too, maybe ask us another time. Our current precedents do not address these situations. We have held the police may enter a home without a warrant due to exigency. But circumstances are exigent only when there's not enough time to get a warrant. And warrants are typically not granted for the purpose of checking on a person's medical condition. Perhaps they should institute procedures for the issuance of these warrants. But, in the meantime, courts may be required to grapple with the basic Fourth Amendment question of reasonableness. These categories of cases discussed are simply illustrative. Search and seizures conducted for other purposes might also be okay, and we're definitely not going to answer those. Fair enough. Fair enough. And then he says, I properly reject the broad category, whatever you might think of these more specific examples. So is there some version of the missing elderly person? Is there some version of the red flag law? Is there some version of the temporary seizure of the person for the purposes of conducting mental health evaluation? Is there some version of that that's constitutional? Probably. So we're just taking note that, even though there's no broad category, because no, There might be specific things, and here's some specific things, which might be constitutional in some version of it. So, a different problem for a different day. Then we got Kavanaugh. Okay. I join the court's opinion in full. I write separately to underscore and elaborate on the Chief Justice's point. The court decision does not prevent police officers from taking reasonable steps to assist those who are inside the home needing aid. For example, as I'll explain, police officers may enter a home without a warrant in circumstances when they're reasonably trying to prevent a person's potential suicide or to help an elderly person who's been out of contact and may have fallen. Ratified in 1791 and made applicable to the states in 1868, the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures. And the constitutional text establishes the ultimate touchstone of the Fourth Amendment is reasonableness. The court has said a warrant supported by probable cause is ordinarily required for law enforcement to enter a home. But drawing on common law analogies and common sense appraisal of what is reasonable, the court has recognized various situations where a warrant is not required. Rakita Law gives me $20. It says, holy Christ, they did it right. I know, Rakita, right? I know, they did it right. It's amazing. And not only did they do it right, Nick, they did it right in 2 pages. The entire Supreme Court opinion is 2 pages. Technically 4, but the first 2 pages of it are 1 paragraph of here is the precedent relating to automobiles, and then a page and a half of here are the facts related to this case. So the first 2 pages are precedent, and here are the facts of this case. That's the first 2 pages. The next 2 pages, and the only other 2 pages of the opinion, are here is the legal analysis. It's very short. I guess you don't need to say a lot, because the legal analysis is there is no community caretaking exception in broad. So the community caretaking exception is not a broad thing that exists. So it's not a separate category of thing. And it's definitely not a separate category of thing when it comes to the home, which is special. So there is no community caretaking exception in the home. It doesn't exist. It's not a thing. It's very short and to the point. Two pages, man. Unanimous. I guess when it's easy, you don't have to say a lot of words. How many words do you need? Not that many, apparently. And now we just have some random musings about some other stuff that we're reading because entertaining. Why not? But yeah, I'm pleasantly surprised. The Supreme Court beat them down. They beat them down hard. Community caretaking is not a thing. 9-0, go away. Awesome. Thanks for the super chat, Nick. For example, exigent circumstances doctrine allows officers to enter a home without a warrant in certain situations, including to fight fire and investigate its cause, to prevent imminent destruction of evidence, to capture hot pursuit of a fleeing felon and possibly fleeing misdemeanant, but we'll get to that in a separate case to be decided soon, or prevent a suspect's escape, to address a threat of safety of law enforcement officers or general public, to render emergency assistance to an injured occupant or protect an occupant who's threatened with serious injury. And then we cite a whole bunch of cases that stand for those propositions because, yeah, that all makes sense. Over the years, many courts, like the First Circuit in this case, have relied on what they've called community caretaking doctrine to allow warrantless entries into the home for a non-investigative purpose, such as to prevent suicide or conduct a welfare check on an older individual. But as the court today explains, any such community caretaking doctrine was primarily devised for searches of cars, not homes. The home was special. Go away. That said, the Fourth Amendment issue is more than labeling than substance. Maybe it is. Maybe it is. We don't really do law by words so much as by what things are. So what a rose by any other name would smell just as sweet kind of idea. So what we call it is not as important as what it is. So the current law allows exigent circumstances doctrine, which allows an officer to enter a home without a warrant if exigencies of a situation make the need of law enforcement so compelling that it's objectively reasonable. As relevant here, one such recognized exigency is the need to assist persons who are seriously injured, citing prior law. The Fourth Amendment allows officers to enter a home if they have an objectively reasonable basis for believing this, and that the officer's actions inside the home are reasonable under the circumstances. This case does not require us to explore all the contours of this. Yeah, we're definitely not going to try to figure out everything relating to that. What are the exact boundaries of that? That's, not our problem today, and we're definitely not going to figure that out right now. Because officers here have disclaimed any reliance on this doctrine. But to avoid any confusion going forward, I think it's important to briefly describe how this applies to some heartland emergency aid situations. As Chief Judge Livingston has cogently explained, although this doctrinal area does not draw much attention from courts or scholars, municipal police spend a good deal of time responding to calls about missing persons, sick neighbors, and premises open at night. And as she aptly noted, the responsibility of police officers to search for missing persons, to mediate disputes, and to aid the ill or injured has never been the subject of serious debate, nor has responsibility of police to provide services in such an emergency. Consistent with this reality, the court's exigency precedent, as I've read them, permit warrantless entries when police officers have an objectively reasonable basis to believe there's a current, ongoing crisis for which there is reasonable to act now. The officers do not need to show the harm has already occurred or is merely moments away, so not necessarily imminent, because knowing that will often be difficult to impossible in cases involving, for example, a person who's currently suicidal or an elderly person who's been out of conduct and may have been fallen. If the risk is serious and reasonable, that might be enough. So you don't need to show the harm has occurred or imminent. You just have to show it's sufficiently real. Maybe. So maybe it's not something that needs to happen right now. Maybe it just has to be sufficiently real on an objectively reasonable basis. A few non-exhaustive examples will illustrate the point. Suppose a woman calls a healthcare hotline or 911 and says she's contemplating suicide, that she has firearms in her home and she might die. The operator alerts the police and 2 officers respond by driving to the woman's home. They knock on the door but do not receive a response. May the officers enter? Of course. Well, the woman herself has said, I am about to harm myself, so the police would have knowledge of an imminent harm. So that makes sense. In that hypothetical, the exigent circumstances doctrine applies because the officers have an objectively reasonable basis for believing that an occupant is seriously injured or threatened with injury. After all, a suicidal individual in such a scenario could kill herself at any moment. The Fourth Amendment does not require officers to stand idly outside as this takes place. Consider another example. Suppose an elderly man is uncharacteristically absent from Sunday church services and repeatedly fails to answer the phone throughout the day and night. A concerned relative calls the police and asks officers to perform the welfare check. 2 officers drive at the man's home. They knock but receive no response. May they enter the home? Of course. This is Kavanaugh's view, by the way, not speaking for the court, but this is Kavanaugh's view. So, is that legally right? It might be. Might not be. But it's at least his view. Officers have an objectively reasonable basis for believing an occupant is seriously injured. Among other possibilities, the elderly man may have fallen and hurt himself, a common cause of death or serious injury. The Fourth Amendment does not prevent officers from entering the home and checking on the man's well-being. To be sure, courts, police officers, and police departments alike must take care that officers' actions in these kinds of cases are reasonable under the circumstances. But both of these examples and others as well, such as cases involving unattended young children inside the home, illustrate the kind of warrantless searches that are perfectly constitutional under exigency. With these observations, I join the opinion. So Kavanaugh has some examples of specific things that he thinks would be exigent, or if not exigency. Because, again, normally, at least the way I conceptualize it, and maybe different lawyers conceptualize it differently, but normally when I think about exigency, I think specifically criminally related. So these examples wouldn't fall to my mind about exigency. But whatever they are, they might work, even though the broad category doesn't exist. So these specific examples work, but even though the specific examples exist, they do not form the foundation for the broad category. The broad category does not exist. So, Very good. Astroth K asked, what I don't understand is why cops have any duty to intervene on a single suicidal person, but of course government can't stand losing a tax sponge. No one said at any point the police have a duty to do this. This case isn't about duty. Nowhere in this case does it suggest the police have any obligation to do these things. This is just suggestions of what the police might be able to do, not what they have to do. So I think your question is a little bit off point, because even Kavanaugh is not saying that a police officer has to do this. He's asking, can they? He even asked the question, may the officers enter the home? Not must they enter the home. Those are not the same question. So yeah. A forward decision on the Second Amendment? No, not so much, but yeah. Shut up. Kavanaugh's ending example seems to hinge on the ability to threaten yourself. Are you legally able to threaten yourself? Yeah. A threat to yourself or others? Sure, why not? Yeah, you can legally threaten yourself. Enough for the government to have a right to interest of intervening. Sure. Sure. You don't think they should be allowed to, even in Kavanaugh's description? That's fine. You can disagree with Kavanaugh. That's fine. You can disagree with Kavanaugh. And Kavanaugh is only speaking for himself here. So yeah, maybe you don't agree with these examples. That's fine. Maybe you don't think those are fine for the police to do those things. That's cool. I mean, Kavanaugh is just literally writing for himself. This is what he thinks. To Truth for Liberty, hypo. I think someone inside needs help, and I will look for drugs when I try to help. What is the limiting rule? Not at this time. I don't understand the hypo. Exactly. We'll see if there's any other. Yeah. Rakita says more of these 4-page opinions, please. Simple, to the point, no muss, no fuss, right? In and out. So yeah, that's about all there is today. It's a very nice decision, very broadly written, very good for the Fourth Amendment, very good for the home. Firearms, scary and all, does not create an exception. Rhode Island gets smoked like a ham, gets shut down pretty hard. Really, really nice. Really, really nice. Surprising, nice, clean. Community caretaking is not a thing. Stop trying to make community caretaking a thing. It is not a thing. That's what we learned from this. If you're enjoying watching these content, please remember to like the video. I do appreciate that you're all here, and I hope you enjoy these discussions and these illustrations and me explaining these opinions and me trying to provide some legal education about what's being written. So I hope you understand all that and appreciate that. So, I try to provide some positive content. If you're not subscribed already, why not? You should subscribe so you can help the channel grow. And did you know for 99 cents a month, you can help the channel grow? It's true. There's a join button, and periodically Streamlabs provides you a link. And if you click on it, you'll get your name in green, and you'll get a little cool icon by your name like A. Hettinger has. And, I will like you more. So all that's plus. So do those things. Until later, my friends, I've been Uncivil Law. Hope all is well. Cheers. And goodbye.